First of all, let me thank you, Marco, Pierluigi, Anna, and Nicola, and all the UI staff for organizing such an interesting event and having me to sharing this panel. As Marco stated at the very beginning, this panel is a sort of follow-up of the previous one because we are discussing about the meaning of fairness within the DMA setting. Much have been said about the uncertainty on the notion, the concept of fairness, on the role of the meaning of fairness when it comes to business user side in DMA and the indirect benefits that may bring to end user. So just try to provide some other thoughts and then leave the floor to our panel. And so let's say that the again, has been said a lot about the origin of fairness when it comes to competition law. If we have to understand fairness in a different way when it comes to competition policy, that means the DMA. And I guess that one of the main reasons we are still looking at competition law is because, as been said several times, DMA is informed and inspired by several antitrust investigation. Second of all, I would say that, as has been mentioned, there is somehow a concern that the reason why the DMA has been introduced and is envisaged is to provide a powerful but at the same time convenient shortcut in terms of enforcement. That this is something that came up also about the difficulties to measure fairness. And I would also say that from this perspective, it has been also highlighted, we may also wondering whether actually there is an enforcement failure, at least in the EU, because as we know, due to the fact that DMA has been inspired and mimicked several antitrust investigations, we may say that we had a huge amount of antitrust investigation regarding digital players in EU. And just to be clear, not necessarily all these investigations last as Google Shopping. I mean, if we look at the National Competition Authority cases, they last around a couple of years. That just to use the terms of our panel is pretty fair in terms of length of the procedure. Third, I guess that the reason why we are still looking at competition law in order to imagine the meaning of fairness from a legal and economic perspective is because actually in the DMA, as we know, we have a definition of fairness finally. And the definition of fairness, I would say, is more close to somehow a competition notion of fairness because it doesn't involve end user. And especially it seems to related to a specific type of antitrust, and not necessarily just antitrust notion, that is the one related to economic dependency. I will try to show this why. Because when it comes to the definition of fairness that has been introduced at the very last moment in the DMA, we know that there are clear references to notions such as imbalance between the rights and obligation of business user, the fact that gatekeepers has a gateway position and a superior bargaining power, so they are able to capture a disproportionate advantage that does not allow market participants to fully capture the benefits of their own contribution. And this wording is literally taken from the economic abuse provision that we find in different European member states. Indeed, the German Monopol Commission suggested actually the European Commission to define fairness in terms of economic dependency. And if we look at Data Act, in particular the Chapter 5 of the Data Act, again, we have a link of fairness with the main benchmark provision that belongs to economic dependency. Somehow I would say that also the definition of fairness in terms of value sharing or surplus sharing has been also inspired by the work delivered by, let's call it the Yale project, because I do not remember the number of colleagues that delivered the paper. At the same time, there has been a discussion about the different goals of DMA in terms of fairness and contestability, and I know that someone do believe that discussion is useless. I would say probably this belong our nature, at least of lawyers. But you know, when you define and you support an intervention according to specific legal and let's say legal interest that you want to protect, and you say that these legal interests are different from traditional competition law, somehow we have to investigate whether they are actually different from competition law. So I don't know whether it is useless or dangerous, but it's part of our job. And finally, I would say that the notion of fairness that we find in the DMA as value/surplus sharing is also, let's say, has been also influenced by the other European competition policy intervention. We may mention the copyright directive, we may mention the current fair share debate between Telco and OTT, we may mention the Data Act. Probably the only competition policy intervention that look at fairness not from the perspective of the value sharing is the platform to business, where fairness seems to me that is just transparency. At the very end, we know that in the DMA, fairness is intertwined with contestability, and this has raised other debate about how much is different from contestability, because as a matter of fact, it seems to me that several obligations, okay, most obligations address both fairness and contestability. Further, the DMA does not identify, does not specify which type of obligation belongs as just on fairness rather than to safeguard contestability. And it seems to me that the goal of fairness is essentially confused or intertwined with contestability. I investigate this aspect in a recent paper that has been published in Antitrust Bulletin. So, as well as Marco did before, I have my own table. So we compare, contrast the way in which we interpret each DMA provision, and looking at the interests that have been protected, the direct, indirect beneficiary. Fortunately, I've not been designated as a gatekeeper. Otherwise, I guess this is a form of self-referencing. And again, it seems to me that some obligations are just transparency, other obligations are just contestability. It is difficult to me, with the exception of Article 6, 12, it's difficult to me to find an obligation that is just fairness. As we already discussed, in almost all the instances, the direct beneficiaries of this obligation are business users, but nonetheless, there are clear indirect benefits also for end user. And I guess this is the part that belongs to my role. So I'm really happy to open the floor to our great lineup of speakers. I just try to collect some idea in terms of open question. As you may imagine, some questions are going to overlap with the discussion and the debate that we already had in the previous panel. It is another, I would say, intended or unintended consequences of fairness. So what I would like to ask to each of our speakers is they are free to address one of these questions or something else if they prefer, is about the different meanings of fairness. Again, the relationship between fairness and consumer welfare, if there is any distinction between fairness and economic dependency, then another way in which we may look at this comparison. Let's think about that unfair is abusive, and then we may discuss whether in terms of exploitation or exclusionary behavior, does it mean that a fair conduct is lawful? Because we know that there is another debate whether you may use some practice that may be fair according to a specific legal field, but maybe determine anti-competitive effects. Does it mean that something that is fair according to other provision shields you from to be, let's say, investigated before antitrust authorities? And finally, This is very specific. I know that. Is there any justification for different treatment under DMA and competition law? I'm just figuring out one of the striking examples that is related to parity clause that we know are forbidden in terms of both narrow and wide under the DMA are not forbidden, at least under the narrow perspective under competition law. So let me introduce our speaker in alphabetical order. We have Flavio Arzarello, Public Policy Manager at Meta, Hein Hobbelen, Partner at Bird&Bird, Loulou Kenens, that is joining us remotely, she's an economist at the Austrian Federal Competition Authority, and Nicola Tosini, that is Managing Director at NERA Consulting, I guess in the Berlin office, if I'm not wrong. Yeah, I did my job pretty well, okay. So if it's okay for you, I will give the floor firstly to Loulou, and then I will proceed with Nicola, Hein, and Flavio. Loulou, can you hear us? Whenever you want, you may jump in. Thank you.
So I want to talk a bit more about the first and the second question. So the third question, so the meaning of fairness and unfairness as views of economic dependence. And I want to talk a bit about the meaning of fairness in a more practical sense and related to a case that the Federal Competition Authority was able to terminate already in 2019. But that is still interesting with regards to the subject that we have today. And I think it is a good practical example for the meaning of fairness and platform. So first, I just want to give you a brief summary of the case. Starting in 2017, the Federal Competition Authority received a large number of complaints about unfair trade practices of Amazon towards Austrian retailers. And in January 2019, a complaint by the Austrian Retail Association on behalf of several marketplace sellers was made. Complaints concerned the conditions for sellers on the marketplace Amazon perceived as unfair by the sellers, and the competition authority opened investigations into a potential exploited abuse of dominance. So in the course of the following month, the authority received several submissions by individual sellers on the Amazon marketplace, and in April 2019, questionnaires were sent out to the 400 largest Austrian sellers on the Amazon marketplace. There was also close cooperation with the German Federal Cartel Office because they actually investigated the same subject matter and was essentially identical in Germany and in Austria. And the authority confronted Amazon and the accusations with the accusations and gave Amazon the opportunity to comment on the complaints, and as a consequence.
Loulou, sorry for interrupting you. If it is possible, can you speak closer to the computer or your microphone, because we are unable to hear you?
Can you hear me now?
Definitely better.
Okay, great. Amazon then agreed to modify several terms and conditions of the business solution agreement, which removed the competition concerns of the authority. So how does this relate to fairness, and what did the Austrian retailers in this case perceive as unfair? Actually, the retailers that offered their products on Amazon, on the Amazon marketplace, observed certain patterns of behavior and business practices towards themselves and provisions in the business solution agreement as problematic. Just to give you a few examples, so they considered the unjustified blocking and closure of seller accounts, the arbitrary extension of delivery times by Amazon, the unequal treatment of sellers who do not use Amazon's logistics service, the restrictions on the marketing of products, a lack of transparency with regard to the product and seller rankings, and pressure to use further Amazon services. So summarizing, one could say that the Austrian retailers perceived a behavior as unfair if it was, in their opinion, unjustified, unequal, restricting, arbitrary, lacking transparency, or pressuring. So coming back to the slides that we saw at the very beginning and this morning, listing the 4 different concepts of fairness, I think this relates most to the concept of correctness. So unfair trading conditions putting certain sellers at a disadvantage. So the complaints actually led to deeper investigations of some of the terms and conditions in the BSA that were determined to be unfair and hence possibly harm competition. And they were afterwards adapted. So now there were stricter limits on terminations or suspensions of seller accounts, ex-ante communications of changes in the BSA, and the removal of far-reaching liability limitations, just to name a few. So fairness is especially important when there are market-dominating platforms, because competition can more easily be harmed when there is a lot of market power. So there is this ongoing discussion about the difficulties in determining market power in digital platforms, because it is often measured by the market share, and since services are often provided free of cost in the digital platform, market share cannot be calculated. So in the case of Amazon Marketplace, the Federal Competition Authority gained information on market power through questionnaires that were sent out to market sellers. And according to their statements, a majority of respondents had hardly any relevant alternatives with which they could reach their customers. Most of the respondents would be prepared to accept a 5 to 10% price rise on Amazon's parts. And those market sellers who claimed that they had alternatives nonetheless earned by far the greatest share of their turnover on Amazon. So I think it is safe to say that a big part of the sellers are economically depending on Amazon, and the unfair behavior patterns could be related to this economic dependency. As can be seen in the case presented, unfair behavior and competition is easier to impose when there is economic dependence. So I think these two concepts are very closely related, and in this case, I think that the abuse of economic dependency could even define unfairness. So how to correctly define fairness in platforms is one of the key questions, in my opinion. And what I can contribute to the discussion about the meaning of fairness in platforms and its definition is the importance of a case-by-case analysis, like it was done with the Amazon case in 2019, especially when there is a market-dominating platform and self-preference can easily harm competition. So competition was in this case perceived as unfair when information and behavior was unjustified, unequal, restricting, arbitrary, lacking transparency, or pressuring. But I think in general, it is hard to define fairness because it can be very subjective, and it is hard to find objective criteria for fairness that apply to all contexts. It is not as clear as other concepts which can already be seen in the existence of various definitions of fairness. So to conclude, I think to correctly define fairness in platform is important, but as the market is evolving, I think it is also important to remember to take into account the context of a specific case and to keep the definition open. And last but not least, this is a bit of a topic change, but relating to the discussion about the interconnectedness of fairness and contestability, I think you could say that these two things are intertwined. In economics, contestable markets are markets often served by a small number of market players that are nevertheless characterized by a competitive equilibrium because of the existence of potential short-term entrants. So there is a threat of entry due to the market having no entry barriers or sunk costs. So no discrimination. So there is no discrimination against entrants. And one could conclude that contestable behavior in platform economy can be understood as the ability for potential entrants to easily enter the market and compete with incumbent market players. And if there is no contestability, there's no threat of entry, incumbent market players can easily engage in unfair competition and make use of market power. On the other hand, if there exist unfair patterns of behavior, it can be harder for potential entrants to contest an incumbent player's market position. So I think it does make sense not to look at these concepts individually, but to look at them as reinforcing one another.
Thank you very much, Loulou. Nicola, please, the floor is yours.
Thank you very much to the panel moderator, Giuseppe, and to the conference organizers, Pierluigi and Marco, and good morning, everyone. So the word fair comes up in the DMA about 89 times. And in addition to that, at least in the final version of the DMA in recital 33, we even see, as has already been recalled earlier today, a definition of fairness, which refers in the first place to the relationship with business users, but also more broadly to the relationship with alternative providers of complementary services, or simply to others. And in addition to that, there is also a reference in the recital to the offering of a service free of charge, which would also suggest that some of the services in questions are really meant for the end users rather than for the business users. And as already been recalled, fairness is defined as an imbalance between the rights and the obligations of the business users and the gatekeeper, as caused by the superior bargaining power of the gatekeeper. And the purest application of this specific definition of fairness in the DMA, we see in the obligation of friend conditions of access to software application stores, online search engines, and online social networking services. So Article 6.12 of the DMA. But some notion of fairness also comes up, in my view, in many other obligations, including the obligation in Article 6.5, so the so-called self-preferencing, and also the obligation in Article 6.2 on so-called Sherlocking, which is the practice whereby gatekeepers may use data in competition with their business users, which is then regulated by Article 6.2. And all of these observations confirm the fact that indeed defining fairness, or even operationalizing the definition of fairness that is offered by Recital 33 is quite an elusive endeavor. And fair apparently comes from ancient German and means beautiful, attractive, peaceful, and bright. And we do see also in the different linguistic versions of the DMA how then in the German and English version the word fair is used, whereby in the Romance versions we see words such as iniquo or inic, or sleale or déloyal. And how elusive it is to define fairness is also suggested by a cartoon that I don't know whether we have here on the slides or not, but in which there is a teacher that that asks to animals in different shapes and forms for a selection. Everybody has to take the same exam. Please climb that tree. And so different then respondents will be in different positions, right, to meet this test or not. And also the paper by Kremer and others that I think Giuseppe referred to as the Yale group comes up with three alternative notions of fairness. The first one, which is the one that is closest to the definition in Recital 33, is really about fairness with respect to surplus sharing. Then there is a second notion of fairness, which is with respect to contractual terms. This is perhaps more a little bit in the spirit of consumer protection, and is reflected in, for example, Article 5.3 on parity clauses and Article 5.4 on anti-steering provisions. And last, a notion of fairness with respect to processes and practices rather than outcomes, which to me relates in particular to then the concept of self-preferencing, and so Article 6.5. And in the same way in which when we talk about strategic interaction, an economist would immediately think about the concept of Nash equilibrium. When we talk about bargaining power and surplus sharing, we would instinctively think about the notion of Nash bargaining, a notion that was also alluded to in the panel yesterday on the telecoms fair share. And according to this framework, so there are gains from trade that needs to be allocated, and they will be allocated based on the bargaining power of the different parties and this disagreement threat points. And maybe short of suggesting that this framework should be used in actual negotiations between the gatekeepers and the business users, right? I still think that the framework is a helpful one to understand really how alternatively this net surplus could be shared if bargaining power and the disagreement points were redrawn. But all of these considerations are still quite static, because they separate really the exercise of splitting the pie from the exercise of determining the sizes of the pie. And in reality, fairness is often quite inseparable from consumer welfare, because what a firm obtains from the bargaining or anticipates to obtain from it is going to affect its behavior on the market. And to further investigate this relationship, I think it is helpful to have in mind a 2x2 matrix of different scenarios. So, and in one dimension of this matrix, we can see whether the gatekeeper is in a competitive relationship with its business users or not. And in the second dimension of this matrix, we can think of whether we are considering competition in the downstream market or competition in the upstream market, which is also known as inter-platform competition, thereby then drawing a reference to recital 16 of the DMA, according to which unfair practices may weaken inter-platform contestability. So the link here is not between contestability and fairness, but the other way around, between fairness and contestability. I don't know how much time I have left, but perhaps I can very quickly go through these 4 different scenarios. In the first one, we don't really have a competitive relationship between the gatekeeper and the business users, and we are considering competition in the downstream market. And in this configuration, then the issue of fairness can really be characterized as an issue of exploitation, where then, of course, the competition consequences would be then related to the passing on of any possibly excessive charges to the business users' customers. If we switch to then the configuration of actual competition while remaining in the downstream market, we can think of then unfairness as self-preferencing, where the competitive consequences could be manifold. So on the one hand, we might have exclusion, although that is by no means necessarily the case, and also the representative from the Commission recalled earlier today. And we might also have the competitive consequence of then disincentivizing business users from innovating. At the same time, these practices might also contribute to intensifying competition and to generate additional efficiencies. Now turning to the upstream market, we can think of situations where we don't have competition between the gatekeeper and the business users. And in this case, then unfairness might take the form of what we could call a customer foreclosure, whereby through parity clauses, through anti-steering provisions, customers, so business users, may have reduced incentives to switch platform or to multi-home, or in the case of anti-steering provisions, be limited in their ability to disintermediate. And really coming to the last scenario, that would be that of potential competition in the upstream market. And here we can think of unfairness as the possibility of discriminating against business users that might pose a dynamic threat in the upstream market. So becoming platforms themselves. But the relationship between fairness and competition seems to be very well recognized by the DMA, as, for example, each obligation tends to be jointly guided by the notion of fairness and contestability. As Giuseppe also noticed in his table, there is only one condition, as far as I can tell, that is exclusively assigned to the fairness objective, and namely Article 6.12 on fund access. And additionally, because even in recital 33 that contains this definition of fairness, there is this very informative reference, and namely the link between fairness and the innovation or other efforts of the business users. So fairness as impinging on the ability and incentive for business users to compete and to innovate. And as a result, I believe that in the enforcement of the DMA, obligations, competition, innovation, and consumer welfare considerations will continue to be relevant and act in a way as a filter in the application of the notion of fairness. So thank you very much. I look forward to the discussion.
Thank you, Nicola. Hein, it's your turn.
Thank you very much, Mr. President. Thank you very much to the EUI for having invited me. So indeed, I have been a private practitioner in Brussels for more than 25 years now. And actually, what I thought when I was preparing for this conference, and I was reading so many excellent articles written by lawyers and by economists, I got a feeling a bit like we seem to be a bit lost in the antitrust community about what fairness is. There's a lot of uncertainty. It's a vague concept. But actually, when you are a private practitioner in EU and national competition law like I am, I was thinking we have known this concept for a very long time. And actually, why is it coming back now? That is what I was wondering. We have known it for a very long time, and I could not listen to all the contributions so far because I got stuck in airports over the last 24 hours. But I think that some people before me must have referred to some treaty articles in competition law where there is actually a specific reference to fairness, Article 102A TFEU. There's a specific reference to unfair purchases, unfair trading conditions in Article 101.3. We have the fair share to consumers. And obviously, as private practitioners, we get called, Professor Siragusa is called very often by clients asking, is this okay, this price? And we can't say, oh, this is a very vague concept. We have to check all these economist articles. We have to apply it in practice. And this is what has been happening for many years. Actually, the first case I did in my entire career, which is one when I was still carrying the bags of the partner I worked for, Onno Brouwer in the Netherlands. It was about fair pricing. It was about a case where RTL, which is a big broadcaster, as you all know, they were not so happy to give for a very low amount their program data to a large newspaper in the Netherlands, the Telegraaf. And actually, the Telegraaf was saying the price you are asking here is unfair. So from day one, I had to deal with this concept of unfairness. And I will come back to it a little bit later, because obviously we are all looking for more certainty. And when I was reading all these very fantastic articles, there's a very good article by the president of this panel, but also by Kramer, Scott Morton, she has also spoken here. And I think the fact that there should be no restriction in the ability to compete, that is the point that I see coming back all the time in this broad discussion about the principle of fairness, because that is, I think, something we see in EU competition law. There is the whole discussion, what is fairness in competition law generally, but then we have to apply it more at practical level, at the conceptual level in the specific articles. This is a distinction I want to make a little bit later. There's a very good article of Advocate General Cocotte. She also really refers to this equal treatments aspect in the concept and the equal opportunities for all. And then there is the president of the Dutch Competition Authority, Martijn Snoep, who refers to it as a fundamental moral and legal value, which has been there for centuries, which begins with the golden rule: don't do to others what you don't want them to do to you. That sounds very Dutch Calvinistic, and he's not for nothing from the Netherlands. But I mean, these are still broad concepts. If you look at the language versions, as you were referring, Nicola, of the DMA, indeed, in the French language, the concept of fair is mostly translated in the DMA as équitable. Again, there is this point of equality for all. But still, I must say that when you read that, you're still like, okay, but how do I need to apply that in practice? And what does this mean in practice? And I think a lot of the discussion comes from the discussion, economic analysis of what the consequences should be of the network effects and economies of scale in the tech industry. Because if you read the articles that I just referred to by Kramer, etc., this is the fundamental point that they make. They say we need a new concept of fairness because of the network effect and the economies of scale, which shields certain companies from competition, and that enables them to extract a significant surplus, contrast to the more traditional industries, if you analyze that. And then if you read the article of economists, you do see a moral and political discussion. And I think, and this is maybe a little bit of a challenging remark to the economists present here, because I see a lot of discontent between economists of what that actually means in practice. I see that some say, okay, if there is this new need for the notion of fairness, that means that the premise is invalid, that the basic idea, for example, of the Chicago School, that whatever the platforms want to do, as long as they don't force consumers to buy their products or use their service, is fine. That is one view. These economists say, no, that is not the situation anymore. And then there is the, I would say, discontent among economists about the justification, what they argue may be too high prices. Are they justified by innovation reasons or not? I see some economists saying yes, some no. So my point is that in applying this principle of fairness, maybe the economists need to help us also a little bit more there, because ultimately it is also then maybe more a political and moral discussion. And I think, and now I come more to the application of the principle of fairness in competition law and in the DMA. I hear what a lot of people are saying about the fact that the principle of fairness is often referred to in the DMA, but actually there are quite a lot of partly or entirely self-executing obligations and prohibitions in the DMA. So I think, I was thinking about it, actually the DMA is what our politicians in Brussels and at the national levels have considered to be fair at this stage in our economy. The DMA is an amalgam of all these political discussions, and there are a lot of prohibitions in the DMA, which I think are the enshrinement of this principle of fairness that we collectively as society in the European Union consider to be the state of fairness at this stage. That brings me more a little bit back to the concrete application of the principle of fairness in certain provisions of the DMA, because there, obviously, the Commission, and we heard it also from Thomas Kramer, with whom I was at the airport yesterday morning when we had our cancelled flight. He stayed in Brussels, I still came here. He was saying we don't need a lot of economic analysis in the DMA because all these principles are self-executing. But it is exactly in the provisions that you mentioned, I think, Nicola, where there is specific reference to the principle of fairness. It's in this friend principle where you see the concept of fairness coming back. And actually, if you look at that, this is a principle, as I started my contribution with, which we know for a very long time. It sounds very familiar to us. And also the benchmarks that the European Union mentions in the preamble and in the articles of the DMA, they sound quite familiar to us. If you look at the case law and EU competition law, by interpreting the concept of fairness, the courts have centered on the idea that, for example, a price is excessive and consequently unfair when there is no reasonable relation to the economic value of the product supplied. And it developed a test whereby you look at the difference between the costs actually incurred and the price actually charged are excessive, and the price that has been imposed is either unfair in itself or compared to competing products. That, in the circumstances of those cases, was a test that the courts thought was a proper interpretation of the concept of fairness. Other interpretations are that you look at prices in other geographic regions. That is something that we as competition lawyers do when we are confronted with questions like that. I'm conscious of time, I'm almost there. We also have case law, for example, DSD, Duale System Deutschland, where the fact that a license fee was made dependent on the use of a specific logo was considered unfair in itself. So what I want to say is that actually we have developed all these techniques to look at what is fair and unfair. And now if you look at the DMN, I did not see that coming back so much in the articles, in recital 62, actually, if you look at the benchmarks that the Commission mentions in order to apply this principle of fairness, they very much resemble those that I just mentioned that we use in EU competition law for decades. Prices charged for different related or similar services or different types of end users. Prices applied in different geographic regions. Prices the tech firm charges to itself. All those techniques we have used for years. They are there. So those people who say we are struggling, we don't know how to apply that, I think that you see that there are quite a number of benchmarks which are really developed in the case law. Two final remarks in that regard. I would also say how predictable do we want this to be? Because if you look at the application by courts and also by the Commission of what are unfair prices, the European Commission itself has very often said, we do not want to be a price setter. We don't want that. Our European courts have also said, in principle, we have a freedom to contract. That is the basic proposition. So in the DMA, you don't see cost-oriented tariffs that certain services have to be applied in practice. So I think it's also good that you cannot entirely predict, because actually I think that is not what we all want. The DMA already is very far-reaching already. And that brings me to my final remark, maybe. Because I work in Brussels, I've worked there for a very long time with many others. If you look at the political discussions around the DMA in Brussels, you heard our politicians saying very often, we want the DMA because we think it is not fair that there is not a European Google. So for them, the DMA, again, it's the enshrinement of the principle of fairness. And the question then obviously is the DMA fair to European business? I am, together with Mario Siracusa, somebody who is quite skeptical about the DMA, because I think that EU competition law could have done and is already doing much more to tackle certain practices which allegedly are abusive. And I think you also see in the Google shopping case law a development in the case law where there is the concept of super dominance, situation of abnormal competition. So I think that competition law has developed. And the question then is, with this over-regulation, with all these regulations, I don't know if I invite you, if you're on a taxi or my mother is needing a lot of care, if you talk to the nurses that take care of her, you ask, what do you find unfair in these platforms? They don't really talk so much about what we say. They talk about the fact that they think it's annoying that you have to say yes all the time. So the question is this not over-regulation? Are we going to make sure that there is a European Google with this regulation? That is what our politicians want. I can only say that the 10 years that I have been coming here, Professor Parker, we have been talking a lot about this subject. There is already the platform to business regulation. We have so many other regulations, and there is still no European Google. So I don't know whether this is the fairness that our politicians are looking for, but let's see. I think that there can be a lot of inspiration found in all the techniques that we used in EU competition law for many years. Thank you.
Thank you, Hein, for sharing with us your lost in translation feelings. You are not alone, let's say. And finally, Flavio Arzarello.
Yeah, first of all, thank you for having me, and thank you for organizing this beautiful roundtable and event today, discussion on a significant topic for the European competition law and more broadly European political and regulatory debate, which is super important for a platform such as the one I represent here, Meta. So while fairness is, I think, part of the European legal framework and is also not foreign to competition policy and competition law, I think we all have to acknowledge that over the last years, the word fairness assumed like a different meaning or different meanings, as Marco mentioned in the previous panel. In my opinion, and not only in mine, I think that fairness has progressively become a sort of keyword to justify some regulatory intervention, which are mostly directed to big tech platforms. There are a second, I think, meaning of the word fairness, which is fairness intended as a justification for redistribution of value within the market or within the value chain. And I want to give you 3 examples of this. Of course, these examples are partially influenced by my Italian perspective, and some of them have also already been mentioned and also discussed in this event. The first one is about the implementation of the European Copyright Directive. Many implementation in different states, including the Italian one, includes what they call the fair contribution for what they call the use of news content by platforms. The second example is the so-called fair contribution for which European telcos are advocating and proposed by Commissioner Breton. And the third example is the fairness in the context of the DMA, which is more about, as I was mentioning, obligations. We see here that in the political debate and in the sense of the European Commission, this word is taking completely different nuances compared to the European legal standards. In the case of news publishers, they are basically advocating for what they're supposed to be a fair value, but basically to have their business subsidized because of a series of circumstances of the technical evolution of the last years. And similarly, the telcos, the big European telcos, are advocating for some of a sort of subsidy for their investments. You see that basically in both cases, both for telcos and for publishers, the principle of fairness is being used and may be abused with the hopes to put a sort of bandage on a problem, but rather than solve the problem once and for all, I would say. And also, this is a risk that has an ex-ante regulatory intervention which is not flexible enough and adaptable enough to the dynamism of industries such as the digital space. And this is the case, of course, I'm referring to the DMA, where fairness is the means through which ex-ante obligations for big tech platforms, as you all know much better than me, have been justified. And while now is something that we take for granted because the debate on the DMA is open, has been open for a few years now, this is a gigantic leap in European regulation, and also implies, because this is an important point which I want to stress, representing one of the companies impacted here, the DMA implies significant adjustments and also in some cases redesigning of platforms, products and services. And so there is an open point here, which is if and to which extent an ex-ante regulatory intervention may influence the design of a product in a free market society. I think that this kind of debate is open and has multifold implications, because as you may see, this kind of redesigning, etc., is not the result of a measured conclusion by some competition authority, but rather is the result of an ex-ante regulation. We have to be quite honest, and in this sense, what Hein said in his super interesting speech helps me a lot, in the sense that the proclaimed goal of the European Commission with this new, what we can call the era of fairness, is honestly to limit what they consider to be the power of big tech platforms and to protect European players. This is the purpose. And so the point here, I think, is also important to highlight that the DMA is not competition policy, law, or economics. It's a kind of industrial policy with hardcore prohibitions for which grants broad discretionary powers to the European Commission, without the opportunity for impacted stakeholders to claim competition law standards. And in this regards, it's also super important to remind us all that no efficiency defense is allowed. And I think this is a clear sign that this kind of approach, even if we cannot consider the DMA as, you know, purely competition law, we have to acknowledge that the European Commission is moving away from an effect-based approach when digital markets are concerned, and they are embracing a more politically driven perspective. And I want to address one point which has already been raised by Hein in his remarks. On the one hand, challenges and disadvantages for big and mostly American platforms. I want to flag that 5 out of the 6 design gatekeepers are American companies, are super clear. Benefits for European businesses and consumers are neither granted nor automatic, despite the purposes of the European Commission. In fact, I think it's important to remind us all, coming to the you know, the Nash equilibrium, which has been recalled by Nicola, that regulation of digital markets is not a zero-sum game. So it means that excessive obligations for big tech platforms are likely, from my perspective, to destroy value rather than redistribute value to the European businesses or consumers. I want to be super honest here, and I want to also acknowledge that some of the obligations, in particular, I'm referring to those for closed ecosystem, think of the side loading, for example, may have beneficial effects for users, in particular in contrast to lock-in or self-preferencing phenomenon. But other obligations, and here I'm referring more to the interoperability for messaging systems or the data cross-use limitations, which is Article 5.2, may force platforms to provide services with limited features for European users, or to delay, for example, the launch of some new products in Europe because of legal uncertainty and because of legal risks. So, and I want to address one point here, which was raised more extensively in the previous panel. Again, this logic behind the DMA seems quite far from the consumer welfare standard in an economic sense. And even if we were to consider the consumer welfare under a broader perspective, so not only considering prices, but also considering, for example, quality, we might be in a position where European consumers might be exposed to, let's say, less quality services, or European consumers might not have access to certain services because of the obligations stemming from the DMA. This is, you know, the opposite of a consumer welfare approach. And also, very quickly, I want to also flag that the way in which the so-called core platform services are defined is a little static compared to the dynamic nature of the platform's economics, and also a little bit ignores the interconnections between the different services and between the different sites, for example, in case of two-sided platforms. There is another consequence, which is that this kind of regulatory framework, this kind of unique European regulatory framework might have the consequence, might brought to an asymmetry, a regulation asymmetry between Europe and the rest of the world. This kind of situation, the consequences of this situation will be clear only in years. And so this comes, this have raised a question. Is this the right way to make Europe compete on the global stage? Is an open question again. The overestimation and vagueness, from my perspective at least, of the concept of fairness brings with it another risk. And this other risk has been raised under a different perspective by previous speeches as well. So we have no guarantee that a lawful conduct, and this is addresses also in part a question raised by Giuseppe in his introduction. We have no guarantee, there's no guarantee that a lawful conduct according to this unclear fairness framework or paradigm won't be exclusionary according to a careful effects-based and traditional antitrust analysis. So what I'm saying here is that this kind of enthusiasm around fairness by European elites brings with it not only the risk of overregulation, which I was addressing earlier, but also a sort of risk of weakening the traditional and effect-based antitrust toolkit, with also, you know, consequences on the relationship between potential local competition authorities and European Commission. And this kind of risk, I think, it's the same kind of risk that we face with privacy in traditional antitrust proceedings. While it's clear, as recently established by, as you know, much better than me, also by the Court of Justice of the European Union, that in the context of the examination of an abuse of a dominant position, it may be necessary for the competition authority to question the compliance with rules other than those relating to competition rule as part of the legal and economic context that antitrust authorities should take into account in any case. Privacy, as any other specific pieces of regulation, must not become and cannot become a business justification, a sort of shield, if you prefer, to pursue or justify anti-competitive advantages. So I'm gonna close with two final questions, which I already addressed a little bit in my speech, but there are two questions I want to leave you with. Of course, my answer here is quite obvious, but I think we need to address them carefully. So the first one is, are we sure that forcing, because this is the unintended consequence of the DMA, that forcing big tech companies to provide different and often more basic or more limited services for European businesses and consumers because of this kind of regulatory asymmetry is a forward-looking choice for Europe vis-a-vis the rest of the world? And the final question, which was already raised by Hein, is that I think I represent an American company, but I am, as most of you here, proud European citizen. So I think that the goal of having the next digital champion here in Europe can be something we all agree on. Is this the right approach, the right set of rules to make this happen? Thank you.
Thank you, Flavio. It's time to open the floor for question, comments. Polis. Yeah, okay.
Thank you very much, Giuseppe. Thank you very much for this inspiring panel. I have two questions. I have a very short question to Flavio, and I have a little bit longer question, but still quite short to you, Hein. Flavio, my question is very short. It's only 3 words. Is ATT unfair? And if it's fair, or if it's not fair, does Meta plan to use DMA as a tool to challenge it? And maybe question to you, to Hein as well. You mentioned in kind of caricaturized fashion this kind of desire of some politicians to establish European Google. I think if you look, can you name at least second tier potential newcomer of European or third tier or fourth tier company who could potentially, hypothetically, become a beneficiary of the DMA inter-ecosystem rules? I think most of the potential newcomers are non-European, so people who try to characterize DMA in this way, you use it as a kind of the politicians. Some politicians refer to this point. it would be interesting to hear how the mechanics, so to say, about the mechanics of this rule. And maybe last point on, we eliminated competition on speed completely. Competition people consider competition on speed as taboo. Should we be so categorical, or maybe we have to be more diversified, trying to consider at least some instances of softening, making more smart our approach to the previous era of categorical prohibition? Thank you.
Other comments, feedback? Please, Konstantin.
Thank you. Thank you for the interesting presentations. I wanted to follow up on a comment made by both Hein and Flavio, following up on Alice's comment too, regarding this idea of protectionism. And I have a comment and a question. I think, and I'm being very honest, that we're being a bit simplistic when we say that the DMA is being protectionist. The EU adopted the DMA to be protectionist. I think that we need to focus on at least 4 remarks. First of all, empirical research shows that the European Commission was not favorable towards mergers involving European companies. If you remember, a few years ago, the European Commission blocked the Philips-Alstom merger, and that would have been an excellent example of industrial policy. It blocked it. However, I do remember the European Commission approving Facebook WhatsApp. One of the main complainants in the Google shopping decision was Microsoft, a European company. The other 2 points were made by Anu Bradford in the context of the Brussels Effect book. We in Europe are not great at fostering international talent. And she uses the example of Sergey Brin and Elon Musk and how these players were allowed to flourish in the US market. The other point that she raised is about having access to venture capital. This is much easier in the US because it's much easier for players to scale instead of being active in a European market, which is very fragmented still. So against this backdrop, my question is, which of the rules exactly you think will stall innovation? And related to that, you mentioned one thing about this notion, broad definition of consumer welfare, and you said that actually the DMA can prevent users from accessing better quality products. In fact, in some cases, it may lead to degradation of quality. Didn't Meta propose a few weeks ago that it would be introducing a fee to allow users to essentially rely on a less personalized service? Do I remember correctly that the DMA says that users should not be given the option to access a service of a degraded quality? Gatekeepers should be prevented from doing that. So which rule would essentially lead to a service of lesser quality for Facebook?
I'm going to collect another 2 comments. The one is coming from Giuseppe. Yeah.
Thank you very much,
comments.
everyone.
Okay.
Thank you very much, everyone, for the great panel. I have a question for Meta, Arzarello, if I may. You mentioned, you stress how challenging the DMA and in general the regulation that is coming out from the EU is for Facebook, for Meta's services in general. I have a specific comment regarding one industry that Meta is struggling with, the music industry. You mentioned in Italy, for instance, the fairness, the fair remuneration that is being regulated now also at national level. Someone says even in a way that is expansionist compared to the benchmark at EU level. But we are aware of the struggle of the news publishing industry with Facebook, the French case. That's pretty much like something that has been discussed in depth. I think we are curious, obviously, about what the next step is going to be. But in the music industry, for instance, Meta had a huge clash with CI, Authors Collecting Society. No, I know. But I'm wondering, since in that kind of case, I'm not a competition specialist, I'm more into copyright. But as far as I understood in that case, also by the intervention of the competition authority at some point, if fairness in the copyright directive and in DMA when it comes to business users like CI is definitely, we can discuss about how to qualify an entity like CI, if it is a matter of how much money is being paid, because the problem that also Facebook, the Meta raised very clearly in Italy at least was, oh, this is so much more than we used to pay. It's 300% more than the royalties we used to pay. And CI objected, well, but now there is Article 17, that helps us also claim more money because the money you used to pay earlier was negligible or insufficient. So can fairness in this respect be measured, or at least linked to an economic benchmark that in the music industry is somehow defined or identifiable? Thank you.
Talking about all the new antitrust tools that National Competition Authority may exploit in competition with the European Commission. I have previously a comment over there, and then Mario.
Thank you. A few comments and a question. We've heard that the DMA is ex-ante regulation and might be over-regulation. Just to remind everybody, it's not yet even applied. And I wonder what kind of over-regulation we are getting there. If you look at the resources the EU attached to the whole thing. Fairness is also a procedural issue. If you look at the current state of implementation, you have 80 people at the European Commission, max. Most of them are not even recruited yet. So I wonder whether this discussion on over-regulation and let's say the threat of overdoing the whole thing is justified. If I would be on your side, I would drink every day champagne because I don't see any willingness to really tackle the issues. And if somebody tells me that normal competition law has been effective, we've been a complainant in several Google cases, the only telco in the world who tried that. The first Google case took 7 years, mixed results. Do we have a real decision in the search case, in the Android case? I think the only effective competition authority we've seen so far is the German one, the Bundeskartellamt, in the Meta case. And that was then stopped by a higher court. It's going on now. And the funny thing is the DMA now stops the Bundeskartellamt. So effectiveness of competition law, I would put a big question mark to that. And if you then look at the balance of power, if we asked, and we are a big company, we are among the biggest companies in Europe, if we want to have a law firm, an international law firm in Brussels, going after Meta, Amazon, Microsoft, or Google, we don't find one. Just to give you an idea. All the big law firms are working for big tech and are conflicted. So, I mean, in terms of balance of power, I wish the EU Commission good luck in implementing the whole thing. We will see not much, that's my forecast. There's a question to Flavio, because you were also referring to our industry. As we are on both sides of the Atlantic, you were referring to products have been delayed in Europe. I'm not aware of any beta product which has been delayed in our networks, but maybe you can give an example. And the other questions, if I look at the ongoing case in the US, where your CEO is just summoned or supposed to be summoned before the courts, it's the FTC and quite an impressive number of state attorneys. Which systems do you prefer, DMA or the US system? I mean, the court in the US is asked to break you up. and the fines could be really big. So what is your preference then?
Mario, please.
Very briefly, I don't think that the DMA is a protectionist tool. I think DMA is the result of a lack of vision, I think. If you think about it, it starts from the premises that those are big platforms which will stay there, and there is no hope that it's going to be, you know, an European platform. I think that's the premise of the DMA, because as you see from the obligations, the main purpose of the DMA is not to really enhance inter-platform competition, but it's rather to enhance intra-platform competition. So it starts from a very pessimistic view that the structure of the market will remain dominated by those players, and it is an attempt to try to improve access to the platforms, fairness within the platforms, and you know, better use by business users of the platform. So for me, it's really a very, you know, limited tool and a total lack of vision. As to the comment on, you know, the antitrust is long, and it depends a lot on the willingness and on the strength of the various authorities. We have examples of cases which have been dealt very swiftly, very quickly. Many authorities now use interim measures, which, as you know, the Commission for years and years and years had totally abandoned. So it's a question of political will. It's a question of strength of the institutions. That's what is lacking in Europe. It's not the tool. It's not that the legal system doesn't allow us to implement it. It's a question of being active. We have the responsibility. There are the legal tools to improve the situation, but we have to use it. And we don't use them. That's the reality of the market. And even if there is not at the moment anybody who is able to challenge, you know, those big players, the situation was the same, you know, with Boeing or with when, you know, the Airbus did not exist. But at that time, there was the political will to take an initiative which could create really a big European player. That's what we lack. It's a question of willingness. It's a question of courage. It's a question of political will. And there are, as I repeat, you cannot say globally antitrust authorities are inefficient. It's not true. It's not true. There are authorities which are more efficient than others. And the Commission is, of course, probably the less efficient because of the complexity of the institution, because of all the reasons that we know, and because of the language, whatever. You know, there are hundreds of reasons why the Commission is so. But we also have the possibility to go directly to the judges. Why don't we use this possibility? We can enforce directly the antitrust rules. So it's up to us. It's not, I don't like always this claiming that the system doesn't work, that we don't have the tools. We have the tools, but we have to have the political and the strength to use them. Thank you.
Thank you, Mario. You know, I'm in the unfortunate role of the one standing between you and the lunch. So what I would like to ask to our panelists, a quick reaction. You have room to, you have space to engage during the lunch on all these questions and feedback coming, starting from Flavio, but because I would allow also Nicola and Loulou that has not been called to by this question to engage, but
so
actually, a couple of minutes for.
So actually, I am the person between you and your lunch. So I will be super quick. So first of all, ATT question. So I don't want to, you know, rely on this concept of fairness because it's too vague. So I cannot say that this kind of concept is vague when it comes to us, and then, you know, evoke this concept when it comes to others. So what I will say on ATT is that that kind of policy from our perspective is discriminatory in the sense that there are different set of rules for, you know, Apple and from third-party players, among which us. That's my only comment on that one. Second question was about quality, if I understood correctly. So I was not referring to any specific examples or product or meta products. I was referring more generally to a potential side effects of some kind of the provision stemming from the DMA. In particular, if you want to, an example of this, the interoperability for messaging system, I think might have this kind of unintended consequence. Again, not specifically for meta services, but, generally speaking. On the CI question, which is, a huge thing for us and has been an incredible, big thing for us. First of all, in Italy, we are dealing with a very specific provision, which is the new version of economic dependency for the non-Italian, participants here, or those of you who are not particularly confident with Italian strange rules. It means that basically, starting from last year, the economic dependency for B2B relationships with platforms is presumed. And it's not clear whether platforms means sort of gatekeepers. So to keep it short, big platforms over every platform. This is not clear. I can explain you the details maybe over the lunch. I just want to tell you something, two things. First of all, SIAE was declared as a quasi-monopolist by the Italian Competition Authority on a different thing. And so, this has a relevance in this story. And the second question about the, the interplay between the European Copyright Directive, Article 17, and the competition law, I want to stress the fact that Meta has in place something like 150 agreement with CMOs such as SIAE, many of them in countries where the European Copyright Directive is in force. So basically, I think that what happened with SIAE was a peculiar consequence of the particular local, both regulation and political balance and relationship in the country. Just to be clear, now the situation is quite solved in the sense that we are in, let's say, we closed an extension deal. So now the music is on and everyone can use the music on our platforms. Last but not least, an example of a kind of product or service which has not been launched in Europe. I think it's quite easy. For example, we didn't launch threads in Europe. I'm not saying that we didn't launch threads only because of the DMA, but because of the uncertain legal framework and the consequent legal risks that a launch of a new product. Up to you deciding whether this kind of new product might have increased the competition, for example, in the social network space, or in the texting, short texting network, social network space. That's all. Thank you.
Hein.
Thank you very much. I really like the comments, and sometimes they evoked a lot of debate. That's exactly what I intended, so that's great. Just a couple of observations. I don't think I said that the DMA, I thought it was protectionist. I think what I try to do in my contribution is, first of all, to give concrete tools on how to apply fairness, because we have a lot of case law, but indeed also to raise a more high-level point. Is this what we want? And that is really what I try to do there, is to analyze what I hear that our politicians are saying in Brussels that they want to achieve, and then the ways in which they achieve it and the tools that they built in order to do that. And then I am really with Mario Siracusa here, that I honestly believe that competition law can achieve a lot. I think you also said maybe with some reform, if we had done that a couple of years ago, it would have made competition law even much more effective. There's also the timing point. That is also a question of resources for the European Commission. And I think if you look at the types of disputes or discussions that we will see in the DMA on these aspects of friends, they may also take quite some time. So what I want to say is, are these the right tools? That is just what I'm wondering from a helicopter perspective. Over the last couple of years, when I saw all these debates on the DMA, we were all talking about it, the European Commission adopted all sorts of decisions under EU competition law. And I thought, there we have a practice which is in the DMA, which is now being tackled under competition law. And the next decision, there we have it. So it took some time, but we got there. And the question is, we pretend obviously as lawyers that we have to know everything which is happening in Brussels. We don't only have the DMA, we have the DSA, we have the Foreign Subsidies Regulation, we have the Data Act. There is a huge spaghetti of new regulation. And the point I was trying to make is all these resources, because I think the gentleman over there was talking about 40 people or 80 people. I mean, if you look at with how many hundreds of millions of Europeans we are, you can wonder how much that is. Is that the right allocation of resources, or would it have been better? And I tend to believe it might have been that we shifted many more people to the enforcement of EU competition law and national competition law. There are all the tools. And I think the politicians could potentially have achieved more of what they want to achieve, at least what they said they wanted to achieve. And then on your point, well, is the problem not in Europe that there are other problems like attracting talent, access to capital, et cetera, et cetera? Absolutely. I mean, this is absolutely the case. And that is exactly also the point I was making. Maybe we should have transferred much more resources, which are limited in Brussels, to looking at these aspects to create this European Google, rather than this. I mean, I have it here. It's 66 pages. It takes a very long time to read. This is the DMA. But I'm not against the DMA. I'm just raising some questions to see whether we achieve, or the politicians achieve in Europe, what they say they want to achieve. Thank you.
Nicola.
Well, I would say that bygones are bygones. So the regulation is now there. And so the effort should really be concentrated on how best to implement it. And I think that, one key contribution to obtaining this goal is really to continue to keep in mind competition considerations, irrespective of what the motives and the rule-based legislative approach that has been chosen were.
And Dulcis in fundo, Loulou, quick reaction.
Okay, actually, I don't have any further comments. I just want to thank you for the interesting debate, and thank you for inviting me. And I don't want to be in the way of you and your lunch any longer.
We share the same feelings. Thank you, everyone. Oh, there is a... So, Constantina, you are keeping us away from the lunch.
Well,
you were...
we need to talk about your table.
Yeah. Okay, let me thank you all the speaker and all of you for the lively debate, and definitely it's time to lunch.